I've been taking my time, taking all of your time, taking all of your time.
Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Hey, my trendies, trendsetters, and my trendy tribe. Shout out to y'all. Hey, my trendies, trendsetters, and my trendy tribe. Shout out to y'all. Hey, my trendies, trendsetters, and my trendy tribe. Hey, my trendies, trendsetters, and my trendy tribe. This is up on the screen now, but I did ask in the poll. Hey, my trendies, trendsetters, and my trendy tribe. 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 Sorry. How does that sound now? My bad. Sorry. How does that sound now? It's a delay. So when y'all type, it's a delay. Then when I talk, it's a delay. Okay. All right. My bad. Okay. And I can change my mic since I won't play a video. So that might be better too on the volume as well. Okay. I apologize. What I was saying was that there is 50-50 in the polls. It was, and the answers on the screen now of who filed the motion. It was Destiny Payton that filed the motion. All right. So let's get into what the motion is about. And if you didn't get a chance to watch this morning, her deadline was most likely yesterday, but we were giving her kind of today as well to pay the money that the court ordered in their final order. But so this is what she has filed as of today. Defendant's motion to alter, amend, or vacate order of August 14th, 2024. Comes now the defendant, Destiny Payton, by and through her attorney of record, Kristen D. Butler, and respectfully moves this honorable court, alter, amend, and or vacate the order of August 14th, 2024, and as grounds therefore states as follows. This cause came before this honorable court for trial on plaintiff's petition for contempt on June 4th, 2024. As such appearance, the parties, along with their counsel, Jonathan Lusk for plaintiff and Kristen Butler for defendant, were present. In consideration of the pleadings and the testimony, the Honorable Court entered an order on August 14, 2024, on plaintiff's petition for contempt. That defendant's petition for Rule Nisi and modification remains pending for consideration and concerns several key issues that directly affect the provisions ordered in this court's order of August 14, 2024. Defendant avers her claims need to be heard in full, as if proven, such claims will directly credit against or abate the costs defendant has been ordered to pay in this court's order. Just to catch y'all up, if you didn't do all parts 1 through 6, is she filed a separate case where she would be the main plaintiff and he would be the defendant, and asking for him to be held in contempt of court. So when she's saying things have not been decided in the other thing, that's the one she keeps referring to when she's saying that. So if you see something referring back to something else, it's referring back to the separate one that she filed, not as a counter plaintiff, but as the plaintiff. Okay, so we'll keep going. The defendant avers, pursuant to her best information and belief, that this honorable court stated during the trial on June 4th, 2024, that the expenses defendant is now ordered to pay in paragraphs 7, 8, 9, and 10 were to be held in abeyance pending the hearing on defendant's own petition, given they touch on the same issues. In the alternative, the defendant respectfully requests the order be amended to clarify that such payments by defendant are not to be made until a final order is entered. So she's saying by her attorney, she's saying that her other case she filed, the petition she filed for the contempt, the Rule Nisi and everything, has to be heard in full and given and rendered a final order before the final order could be honored in the one that was already ruled in LeBeric's favor. So it goes on to say, that said, requested abeyance and or clarification would be in the best interest of the parties, the minor child, and judicial economy for such matters to be held until testimony can be fully given on such issues. As the parties have a litigious history, and this will prevent any actions or attempts to collect that may cause irreparable harm to the defendant. Further, should an appeal be taken by either party, this will allow both parties that touch on the same issues to have the same timeline for any potential appeals. Upon the defendant's best information, defendant being Destiny. Y'all can't hear me? Let me do a sound check. Can you hear me right now? Okay, thank you, TD Love. All right. Upon the defendant's best information and belief, the expenses referenced in paragraph 8 of the court's order were debt collection expenses incurred during the marriage of the parties, pursuant to the testimony of both of the parties. Defendant avers that the final judgment of divorce, paragraphs 9 and 10, previously addressed the pre-divorce debts of the parties, and that such costs were not allocated to the wife. Now, this is where I start to be confused, because she references that, and it was in the original agreement of the divorce, there were no debts for either party that they kind of owed. They just carried their own debts. But she incurred debts once it was agreed she could stay in the house for the months that she can stay in it until it was sold and stuff like that. And everything that was referenced, from what I understood in that final order where it came up to the $23,000, was after that point. So I don't know if the attorney is humoring her or I'm totally misunderstanding that divorce agreement that we did. We read it together. I don't understand how that could be misunderstood, that the debts she was ordered to pay came after that agreement, not prior to the agreement. Because she had agreed to pay the HOA fees. She had agreed to pay mortgage, taxes and escrow, all the things that the final order laid out. She had agreed to that until the house was sold. Then, of course, he had to take her to court because she was stalling on the house being sold, apparently moving the for sale sign and things like that. Shan, you right. I keep forgetting that. Yeah, okay. But shouldn't the attorney have read over the agreement though? Like, because we know Destiny do not tell the truth. But shouldn't I thought the attorney would have read over the agreement and seen the bills and the dates? Like, that's crazy. Okay. Well, okay. So she's trying to say that their divorce agreement had nullified any debt between she and LeBeric. Like, she wouldn't owe him anything. But again, for me, the things that she had to pay came after that, not before that. Defendant avers that the restrictions on defendant's speech as interpreted from paragraph 12C5 of the party's final judgment of divorce and paragraph 1 of the final order of this court has effectively infringed on defendant's ability to exercise her constitutionally protected free speech. I saw it, but it passed by. Somebody said Destiny couldn't get the money from Stormy. I'm like, it says that while the final judgment of divorce merely restricted defendant's speech on Love and Marriage Huntsville, this court's order has expanded such unambiguous restrictions by holding the defendant in contempt for interviews and discussions in locations, platforms other than Love and Marriage Huntsville. Now, here's the thing, y'all. When I read the where they could not speak ill of each other on both ends, it seemed like you couldn't even talk to like your auntie about it. Like, it seemed like it didn't have to be a public platform, is how I read it. It was like, you just, whatever happens with this here has to stay with you. That's how I took it. So it's interesting that she's keeping it to it only said she can't speak about him on Love and Marriage Huntsville, the show, period. Because I definitely feel like we read other paragraphs that went into more detail. Again, you can see parts 1 through 6 where we went through this. It says, as Alabama Court of Civil Appeals states in Belcher v. Belcher, a divorce judgment should be interpreted or construed as other written instruments are interpreted or construed. The words of the agreement are to be given their ordinary meaning, and the intentions of the parties are to be derived from them. Whether an agreement is ambiguous is a question of law for the trial court. An agreement that by its terms is plain and free from ambiguity must be enforced as written. An ambiguity exists if the agreement is susceptible to more than one meaning. However, if only one reasonable meaning clearly emerges, then the agreement is unambiguous. Thank you, Shan, my memory bank. That based on the reasoning set forth in Belcher, the final judgment of divorce of the parties is unambiguous, and as set forth in paragraph 12C5, restricts only the language on the television show that she is associated with, namely Love and Marriage Huntsville. Such restriction is explicit and narrowly tailored to address one specific television show. Plaintiff's allegations include statements that the defendant acted contemptuously in exercising her free speech by speaking on The Unbreakable with Destiny Payton, OLFP, Ooh Ladies First Panel, Morning Mindset with Ty, The Nightcap with Carlos King, On 10, and Woman to Woman. Notably, none of these shows are restricted by the plain, unambiguous language of the agreement. That these restrictions have left defendant in the impossible position of having to decide if she allows her reputation and ability to earn income to be destroyed while she remains silent, effectively assenting to the accusations and gossip, or speaking up for herself and being held in criminal and civil contempt, especially given such restrictions only limit the speech of the defendant. We clearly read it actually does limit the speech of both of them. If you're only listening to this one thing, I highly encourage, if you want the full thing, to please look at the other parts so you can see that it's just not restricted to what she can and can't do. It restricts both of them. That's why she also has a petition for contempt to hold LeBeric in contempt, because she's saying he violated it by speaking poorly to other people about her. So it definitely holds them both responsible, and that's why she's trying to now get a judgment against him. The contempt motion is done, Messy and KY. This is what happened. Is this Messy in Kentucky? But that's what happened. He's already, his lawyer already filed the original motion of contempt back in September 2023. They won that motion August 14th, 2024. That's where the final order came from. That's why she's facing 45 days in jail, but it's suspended for 2 years as long as she's on her best behavior per the final order. And she owes him like $23,000 that was due by most likely yesterday. So yeah, that's already been done. This is his lawyers, that's taken care of. She's contesting it, basically saying like, can it be vacated, averred, or whatever. That's my question, Samantha. That's exactly my question. How is she trying to get a judgment against him for something she is now saying does not exist against him? Now that's where my question is coming from, because you can't. How do you have it both ways? I don't know. Okay. It says that the Alabama courts have found that in discussing the right to privacy, that the right of privacy does not prohibit the broadcast of matter which is of legitimate public of general interest, and that the right of privacy does not exist where the plaintiff has become a public character and thereby waived his right to privacy, nor in the ordinary dissemination of news and events, nor in connection with the life of a person in whom the public has a rightful interest, nor where the information would be of public benefit. Smith v. Doss. The Supreme Court of Alabama has determined the appropriate test of whether a party is a public or private figure, specifically in Mobile Press Register Inc. v. Faulkner. The court adopted Subpoena v. Cowles Magazine and Broadcasting Inc. to define public figures as people who are numerous and include artists, athletes, business people, dilettantes, anyone who is famous or infamous because of who he is or what he has done. The Mobile Press Register Court also adopted Gertz v. Robert Welch, which clarified the definition of a public figure as those who, by reason of the notoriety of their achievements or the vigor and success with which they seek the public's attention, are properly classed as public figures. That both the parties fall into the category by their own testimony, particularly the testimony of the plaintiff being LeBerick. This is attention actively sought by both parties, as made apparent by the fact that the plaintiff signed an appearance agreement to be on Love and Marriage Huntsville, employed his public social media page to announce the finalization of the divorce, and plaintiff has been contacted by bloggers and or journalists inquiring about the marriage and post-divorce matters. Let me clarify, or let me just say this. I ain't never reached out to that man, just so y'all know, in case you're wondering. I ain't never reached out to him. But I want to say this. In the fact of how they're defining public figures, this could well and true be that LeBerick is a public figure. The problem is they mutually bilaterally signed a contract saying they still would not speak about each other. That's more the problem. So you have to order that contract. You have to you have to argue against the contract that you signed. I will tell y'all too, somewhere in one of the other counter petitions or the new petition, she did say that she signed under duress or coercion. That's what she is saying, just so you know. But for now, the contract agreement is being upheld in the courts so far, which led to her actually being found in contempt on 9 separate acts. So, but yes, is he a public figure by definition? It does sound like it. But I don't think the argument was that they can't talk about it because they're public figures. The argument was they signed an agreement where they wouldn't talk about each other. I think that's the part you have to prove that you could still do that anyway. So it says, given these facts, it seems difficult to dispute that the parties fall into the category of anyone who is famous or infamous because of who he is or what he has done. Defendant Destiny avers and is eager to provide proof as necessary of the numerous videos, blogs, and posts about every development that has occurred in this case. I giggled when I highlighted that. I'm not gonna lie, because but it says she's eager to provide all the things that came out that have about every development that has occurred in this case, including the denial of the motion to seal and the order at issue in this motion. Given that both parties have willingly and intentionally made their personal lives of public interest and continue to do so, the right to privacy does not exist for them as it does for the average individual. Again, technically, there's logic in that law. I mean, because it's already case law for it. But you signed an agreement saying y'all can't talk about each other. So I think that you don't have to argue that contract right there. Well, see, that's the thing. It's not so much fame as public figure, Eva. We only know him because of Destiny, and he went on Love and Marriage Huntsville. So if you're part of the Love and Marriage Huntsville crowd, you know him. But it's not talking about, it doesn't even have to be like a big thing of fame, because I think aren't politicians and stuff considered public figures too? Like they could be like a oh my gosh, an alderman or something, or whatever their titles are. They're like really like in the local level. You're still public figure, I think, when you take certain roles up. You don't have to be super famous to be considered a public figure. But her argument has to go back to that contract they signed, though, not just in general. He could be considered a public figure. Okay, so it goes on to say that such order functions as a limitation of speech by governmental order. The Alabama Court of Civil Appeals has stated, in the context of governmental restriction of speech, it has long been established that the government cannot limit speech protected by the First Amendment without bearing the burden of showing that its restriction is justified. In the same case, the appellate court clarified that the analysis does not change simply due to the litigant being a private actor. Hey, DG say you talking right, Trending. They waived their rights to speak publicly about each other in the divorce decree. Thank you. That the Alabama courts have found orders restricting extrajudicial references to a case must be extremely careful not to abridge the constitutional rights of litigants. Court orders restricting trial participants' speech are evaluated under the prior restraint doctrine, which requires that the record establish that the speech creates a potential for prejudice sufficient to justify the restriction, and that it demands a nuanced approach to the delicate balance between the necessity of avoiding a tainted jury pool and the rights of parties to freely air their views and opinions in the market square, now taking the form of the electronic square known as the internet. In this same case, the Alabama Supreme Court also notes that prior restraints face a well-established presumption against their constitutionality. Given the defendant's speech could in no way prejudice the outcome of the litigation, as there is no jury to taint, and given the large amount of news already circulating about this case, the only practical result is the order leaves defendant defenseless against any public claims made by or on behalf of the plaintiff or third parties. It also leaves the defendant without the ability to earn income from the sources she did historically throughout the marriage and after the entry of the final judgment of divorce. That the defendant has filed her own request for attorney's fees in her petition, and that the defendant avers upon best information and belief that she understood such issues were to be held pending the resolution of this matter in full. Defendant further avers that the costs stated by the plaintiff and that the defendant is ordered to pay are upon best information and belief, in part in response to the filings made by the defendant, matter which has still not been ruled upon. So again, she's referring back to her petition that she filed, that since that has not been ruled upon, she and her attorney have the stance that she should not have to pay this final order yet because they don't have a final order on her petition that she opened. Okay, it says, wherefore, premises considered, defendant respectfully prays that upon a final hearing of this motion, your honor will enter an order opening the final order requiring the taking of additional testimony, if necessary, and altering and amending the final order as to paragraphs 3, 4, 5, 6, 7, 8, 9, and 10 as referenced herein above, or in the alternative to stay the enforcement of this order until the pending matters are addressed. Defendant prays for such other further different or more general relief to which she may be entitled in the premises. So, okay. If you didn't get all that, hit the replay. I am going to try, if I can find it within the next 2 minutes, I'm going to look for where they referenced the divorce decree before, just to bring up the terms. I feel like it's probably in one of LeBeric's filings. So I'm about to look. So y'all can hang out, but that I have read the full document of the motion that was filed. So now I'm looking for the one that says what they can and can't do. So it might be quiet for a second. Okay, I'm opening his original petition to see if it lists some of the paragraphs in there. To see. Yeah, I might just, yeah. Okay, we could do that. Let me see. I'm looking for something better if I can find it in time. Because I have what he cites, but if I could pull up the other one quicker, I want to get something a little bit better. Let me see. It might be in here. This one might, is this the one? It might not have the modification, but I think it'll give us the general idea. Let's see. Okay. Yeah. Okay. Hold on. Yeah, here we go. Miscellaneous provisions. Let's see what page is this on. I'm bringing it up. Hold on, y'all. We're going to go to the whole section of paragraph, or not paragraph, but the whole section of 12, and not just the one they pulled out that mentioned love and marriage Huntsville, because it's more than just that in section 12. So this is the answer, waiver, and agreement for taking of testimony. Hold on. The affidavit. I'm double checking myself. Hold on. Oh yeah, y'all need to see the affidavit too. It's all the same thing. Cause yeah, let me just bring it up. I'll just bring it up. Take this down. All right. So the affidavit says, personally appeared before me, the undersigned notary public in and for said county and state LeBerick Williams, by me first duly sworn, deposes and says, my name is LeBerick Williams, and I am the plaintiff in the above style cause, and I am over the age of 19, of sound mind, and bona fide resident citizen of Madison County, Alabama. It says, my wife, Destiny Williams, is over the age of 19 and sound mind. Okay, that's the final divorce. Hold on, that's not the one I want. Let's keep going. Here it is, settlement agreement. So y'all can see that. Settlement agreement, okay? So we're going to go to section 12 because that's where she says the language is the language is ambiguous. So we're going to section 12 where it does cite love and marriage Huntsville, but it does do more than just that in section 12. So we can look at it. Okay, so here's section 12, miscellaneous provisions. Destiny cited 12C5 in her motion that she just filed that we read. And that's the paragraph that says the wife shall not speak of the husband, his family, or the like on the television show that she is associated with, namely Love and Marriage Huntsville, either directly, indirectly, or implied. But there's paragraphs 1 through 4 before that, and we got some more stuff. So here's the whole miscellaneous section for 12. So, please like the video. Please, even if you're in the bushes, just come like the video. Thank you. Okay, it says, so paragraph 12A says, the parties hereto do hereby covenant and agree, each with the other, to execute all papers and documents, including deeds, bills of sale, as shall be necessary to fully and finally consummate this agreement. The husband and wife covenant and agree that they have reached a satisfactory agreement as to the fair and equitable division of any and all other assets and properties, either real, personal, or mixed, and of any nature whatsoever, which they may own or have any interest in, or which they may own or have any interest in. Further, that each fully disclose to the other the nature and value and location of all said properties, and that each is relying on these disclosures in executing the agreement, and is further being induced to execute this said agreement as a result of said full disclosures. The parties hereto do hereby covenant each with the other the following. So both agree to this. DG, I'm trying to keep an eye on your stuff. Shan, let me know if I'm saying this wrong. So they agree to these things. So it's paragraph C, subparagraph 1, that each shall refrain from any and all words, conduct, deeds, and activities which are intended or calculated to interfere with, abuse, embarrass, or intimidate the other. That each will respect the privacy of the other from and after the date hereof. That each will refrain from any activity, words, or deeds intended or calculated to interfere with the employment of the other, or calculated or intended to interfere with the family or social life of the other. The parties and members of the family shall each refrain from assaulting, contacting in person, contacting by telephone, threatening, harassing, interfering with the employment of, or coming onto the place of employment of either party. Further, the parties and members of the family shall refrain from coming around the residence of either party, talking to, striking, molesting, cursing at, injuring, or beating either party. The parties shall refrain from calling each other at their respective places of employment. The wife shall not speak of the husband, his family, or the like on the television show that she is associated with, namely Love and Marriage Huntsville, either directly, indirectly, or implied. The parties respectfully acknowledge that this agreement constitutes the entire understanding between the parties and supersedes all and any other prior agreements, if any, heretofore made between them, other than those herein expressly set forth. The parties further respectfully acknowledge that each has signed this agreement freely and voluntarily. It is agreed between the parties that this agreement shall be filed in the Circuit Court of Madison County, Alabama, and they both signed. There's LeBerick, and then there's Destiny. Now, here's what I want. The last thing, I know there's still gonna be loose ends. There's always loose ends, but I just want to point out one more time. Let's see. Paragraph C1, 2, and 3. Okay. That they have to refrain from any activity, words, or deeds intended or calculated to interfere with the employment of the other, or intended to interfere with their family or social life of the other. And right, it says they agree freely, right, just Mia. Now I know that there's times people have signed things. You know, I'm not it's happened, but I want to, the last thing I want to show y'all is what was granted per LeBerick's petition. Not granted in the final order, but just to show where he cited that, because she was found in contempt for 9 acts. So I'm trying to pull up what he had just to show y'all that on 10 was ruled. Okay, I'm just gonna show you. We'll go over it. Let me just go over it. I'm just gonna open it because I know I do not need to be trying to freestyle. Hold on. Let's do amended petition. So that way I know I'm looking at the most accurate one. Okay. Because he actually had to go back and add more after that first time. All right. So just to show y'all. Okay. It says, since the entry of the last order, the defendant has willfully and deliberately refused to abide by the divorce decree by doing the following: failing or refusing to pay the plaintiff $1,500 for uninsured medical expense arrears as required in the previous contempt settlement agreement, by failing or refusing to pay additional uninsured medical expenses of the minor child since the execution of the last settlement agreement, failing or refusing to pay the full escrow payments, HOA fees, and lawn care fees of the marital residence to the sum of approximately $3,620, by failing or refusing to pay her portion of the guardian ad litem's fees from the previous court action. Her willful failure to pay her own debts is tantamount to authorizing her individual creditors to place liens upon the marital residence, the formal marital residence. The modification agreement entered into by the parties dismissed all claims of contempt without prejudice. This was pre-September 2023. The agreement stated, upon any further instance of contempt committed by a party in the filing of a petition before this court thereon, the parties may revive claims of contempt made in this action for final disposition in any subsequent action. So everything else was wiped clean, but if somebody did something else in contempt, they could bring it back up, which is what LeBerg did September 2023. Okay, it says, due to the new contemptuous acts by the defendant, the petitioner revives all of his previous claims for contempt in the prior modification action, specifically that the defendant has willfully and deliberately refused to abide by the divorce decree by doing the following. I'm just counting 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Okay, so he did more than 9, because she was found in contempt of 9 of the acts, but he submitted 12 acts, just so you know. But let me show you this. Where is it at? This part. Letter L, by consistently failing or refusing to respect the privacy of the plaintiff by publishing details related to the plaintiff, his family, and his career on a variety of media outlets, including but not limited to the following: the television series Love and Marriage Huntsville, the YouTube program The Unbreakable with Destiny Payton, the streaming web series OLFP, Ulay's First Panel, shout out to Ulay's First Panel, the Instagram live publication Morning Mindset with Ty, the television show The Nightcap with Carlos King, on her musical recording On 10, and on the television show Woman to Woman. So that's just a section of it. So out of the ones he put forth, 9 of them she was actually found to be in contempt, and each act held a maximum of 5 days of jail time, and so that's why she's up to 45 days, but it's suspended for 2 years, depending on how things go for 2 years. So if you missed anything from that, now go ahead and hit the replay. I'm sorry for the echo in the beginning. When it finishes processing, I'll cut that part out. I'm so sorry about that mic issue. I had my volume low, so I couldn't hear the echo myself. So hopefully, here we are. Here we are. So we'll just keep following it unless they end up actually sealing it, and then I can't see anything. but we'll follow it. It is what it is. We knew that. I feel like most of us guessed that she would file something at it's not even the 11th hour. It's really like the 13th hour at this point, because again, technically the payment was due yesterday, I think. So here's what's interesting. This is the worst outcome for Destiny if the court, because the court said we've seen you too much in their final order. They said you are a very litigious couple, is what the court said, right? So if they find that she is a problem and they don't uphold this new petition that she filed, they could say you right now could possibly be committing a contempt or committing something because she didn't pay the money by the deadline. So I'm not saying that's what's going to happen. I'm saying it's the worst possible outcome. The next thing is that, unfortunately for LeBerg, this could be drug out while they go through the petition that she filed. Then they mentioned appeals. So I feel bad. My gosh, I would not want to be in court with Destiny. Lord help anybody. So yeah, that's where we're at. Hit the replay if you missed anything, but hopefully I connected the dots as much as I could. Please hit the like button. Oh my gosh, half of you liked the video. Please like the live. Thank you. And if you like a lot of legal stuff, please support my separate channel, additional channel, Legal at Some Point. I would greatly appreciate it. We will have other stuff over there. It's a baby channel. I only told y'all about it like 3 days ago. So, but please support. We are over there doing YSL stuff. Okay. All right, y'all. Thank you for your time. I saw something and hopefully she hasn't gone live yet, but I'm about to get off here because I saw something where Queen Sheba might be going live. So, all right, y'all. Talk to you later. Bye.
I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time.